Section 15 of your Rule 110 is about the place where your criminal action is to be instituted. If you are going to compare that to your civil procedure, this is about the venue. Section 15 is the equivalent of your Rule 4 of the Rules of Court. So where are you going to file your criminal action or your criminal cases? Answer can be found in your letter A. It reads, subject to existing laws, the criminal action shall be instituted and tried in the court of the municipality or the territory where the offense was committed or where any of its essential ingredients occurred. So again, what is the venue if you are going to file your criminal case? Answer is municipality or territory where the offense was committed or where any of its essential ingredients occurred. But take note ha, take note, ang pinag-uusapan pa lang natin dito is the general rule. For you not to forget the concept of venue in your criminal actions, please remember these two people. When they went to Tagaytay City, take note that they just went there to have a quick vacation. So itong dalawang to are not residents of Tagaytay City. They are residents of Metro Manila. But why is it that the case filed against the guy was filed in Tagaytay City? Because of your Section 15. Because again, Section 15 talks about the venue, and the venue in your criminal case is the place where the panggugulpi or where the pambubugbog or where the offense was committed, or it can be in a place where any of the essential ingredients occurred. Let's compare to your civil procedure. Before you answer what is the venue in your civil cases, first ask yourself, what kind of an action is involved? Is it a real action? Why? Because if it is a real action, then the venue is in the place where the real property is involved or a portion thereof is situated. Basis, this is your Section 1 of your Rule 4, venue of real actions. But ano ba ang real action? According to Section 1, a real action is an action that affects TPI. What is TPI? Title, possession, or interest. So if it is an action that affects the title, the possession, or interest in real property, then that is a real action. And again, where are you going to file your real action? In the place where the real property involved or a portion thereof is situated. The same is true also when you talk about forcible entry and detainer action. This is your Rule 70. The venue is in the place where the real property involved or a portion thereof is situated. We are talking about the venue ha. Pagdating sa jurisdiction ng forcible entry and detainer actions, answer is in the MTC. What if the action involved is a personal action? Then wag urada-uradang sasagot ha, because merong possible answers. There are two options. The first option is you can file it in the residence. Residence of whom? Residence of the plaintiff or the residence of the defendant. But when you talk about the defendant, you have to determine whether your defendant is a resident defendant or a non-resident defendant. So sa pag-plaintiff, walang problema because it is the residence of the plaintiff or any of the principal plaintiff resides. Pagdating sa defendant, again, kasasabi ko lang, you really have to determine what kind of defendant do you have, because if he is a resident defendant, then you are just going to file it where the resident defendant or any of the principal resident defendant resides. But in the case of a non-resident defendant, where he may be found and at whose option? At the option of the plaintiff or at the election of the plaintiff. I suggest if you are going to write this in your booklet, you write at the election of the plaintiff, because that is the language of the law according to section 2 of your rule 4, at the election of the plaintiff. Another possible answer is this group. You can file, or the venue is in the place where the plaintiff resides, or the place where the property or any portion thereof is situated. But kailan to nag-a-apply? Take note of the requirements. Take note that your defendant must not be a resident of the Philippines, at hindi nag-i-stop dyan. Hindi lamang yung defendant non-resident of the Philippines, but he must not be found in the Philippines as well. Magkaiba sa non-resident defendant dito, because your non-resident defendant here can be found in the Philippines. In this case, he cannot be found in the Philippines. Common example is if you have a friend and he has an American ex-boyfriend. Yung American ex-boyfriend niya nakakita na ng panibago, another Pinay. And your the American ex-boyfriend is now in Siargao, vacationing, binibisita yung bagong girl. And you found out that he is in Siargao, then if you want to file a case against that ex-boyfriend, then you can file it in Siargao, because your ex-boyfriend can be found in Siargao even though he is a non-resident of the Philippines. Unlike here, if your American boyfriend is in America, hindi pumunta sa Pilipinas, hindi binisita yung bagong girlfriend, then your options is you in the plaintiff, the residence of the plaintiff, or where the property is situated. But take note ha, hindi lamang ito ang requirements, because you have to make sure that the action affects the personal status of the plaintiff, or the action affects any property of the defendant, and that property must be located in the Philippines. Basis, this is your section 3 of your rule 4. We'll go now to the exception, because what we talked earlier was the general rule. So in your criminal case, the exception is the famous Article 2 of your revised penal code. So even if the offense was committed in Europe or in America, as long as it was committed while on a Philippine ship or airship, or there was a forging or counterfeiting of any coin or currency note of the Philippines, or there was an introduction of this forged coin or counterfeited currency notes. Ito, yung number 4, tinatanong palagi sa bar exams, if they are public officers or employees and they committed an offense in the exercise of their functions. Remember that case, yung consul involved, or was it an employee na humihingi ng sexual favors from the OFWs na nagko-complain, then he was charged also in the Philippines because of this, number 4. And number 5, he committed any of the crimes against national security and the law of nations. Again, this can be filed in the Philippines even if it happened outside of the country, or even if this happened in Europe or in America. And according to your letter D of your Rule 110, Section 15, you are going to file this, or crimes committed outside the Philippines but punishable under Article 2 of the RPC shall be cognizable by the court where the criminal action is first filed. In civil, there is also an exception, and the exception is in those cases where a specific rule or law provides otherwise. Example dito, yung sa family law, yung sa in case of adoption, di ba, ang rule dyan is where the adopter resides. And letter B, ito ang palaging tinatanong din sa bar exams, where the parties have, first, you have to meet the requirements. They validly agreed in writing. Number 2, they agreed before the filing of the action. And number 3, the venue must be exclusive. You have to take note of this before you can apply the exception. In summary, if you talk about venue in your criminal case, all you have to remember is the place where the offense was committed or any of its essential ingredients occurred. But pag tinanong ka sa civil, then you have to determine what kind of an action involved. Is it a real action or a personal action? Pag real action, what is the venue? It is the place where the real property involved or a portion thereof is situated. Pagdating naman sa personal action, huwag urada-uradang sasagot because the venue can be the residence of the plaintiff or the residence of the defendant. Take note, what kind of defendant do you have? Is it a resident defendant or a non-resident defendant? And at the election of the plaintiff. The other option is in the residence of the plaintiff or the place where the property or any portion thereof is situated, as long as you meet the requirements that we have already discussed. Exception in your criminal case, that is your Article 2 of the Revised Penal Code, then in the venue in that case is where it is first filed in your civil case, where the specific rule or law provides otherwise, or there was a place agreed upon, as long as you meet also the requirements required by the law. Let's go to letter B, section 15 of your Rule 110. If the offense is committed in a train, in an aircraft, in a private vehicle, or in a public vehicle, so where is the venue? The venue is the place of departure, the place of arrival, or the places where that train, aircraft, private vehicle, public vehicle passed by during its trip. So kung yung nangyari ang krimen in a bus na ang ruta ng bus is Manila to Baguio, then saan ba dumadaan ang Manila to Baguio na ruta? It passed by Bulacan, Pampanga, Tarlac, Pangasinan. Then you can file your case in Manila, Pampanga, Bulacan, Tarlac, Pangasinan, or Baguio. Pwede yan maging venue. Next, letter C. If the offense is committed on board a vessel naman ha, kung kanina dito, land trip and air trip, dito naman sa dagat, sea trip. So where are you going to file your criminal case? Answer is in the first port of entry or the places where it passed during its voyage. So kung dito sa air trip at sa land trip, place of departure, place of arrival, take note pagdating sa vessel, the port of entry only. The first port of entry do not include the port of exit. And here, take note of the terms used, where it passed by during its trip, here where it passed by during its voyage. Letter C reads that the criminal action shall be instituted and tried in the court of the first port of entry or any of the municipality or territory where the vessel passed during such voyage, subject to the generally accepted principles of international law. Last point, in your civil cases, whether that civil case is a real action or a personal action, take note ha, kahit forcible entry yan or unlawful detainer, that is your Rule 70. But since it is a civil case, rules as to venue can be waived and it can also be a subject to an agreement. Again, whether it is a real action or a personal action, pagdating sa usapan ng venue, it can be waived and it can be subject to an agreement. This is the opposite when you talk about your criminal cases, because in criminal cases, venue hindi pwedeng i-waive, venue hindi rin pwedeng pag-usapan. It cannot be waived, it cannot be subject to an agreement because in your criminal cases, venue is jurisdictional.